Okay, welcome back, everyone. Thanks for sticking around before lunch. This is the last panel before lunch. Bruce will explain how lunch is going to work. And thanks to everyone online who has stuck around as well. Okay, we have another all-star panel. Really looking forward to this one about the law enforcement liaison. Again, the fun thing about these panels is it's also new because of the new administration. So it's the perfect time to start to get into this because we have a lot of former people, a lot of real expertise to sort of give you an idea of what to expect. So let's get started. Okay, Luke Dembosky, the co-chair of the Data Strategy and Security Practice at Debevoise and Plimpton. We all know about Luke's accolades, everything that Luke has accomplished, but what you may not know is the unique experience that Luke has had. He was DOJ's resident legal advisor at the U.S. Embassy in Moscow, and I think he's the only one today, both with attendees and panelists, who's ever done that. I think there's only a half a dozen or so who have done that. He was deputy chief for litigation at DOJ at CSIPS, the Computer Crime Intellectual Property Section, where he oversaw all these big data breaches, Target, Sony, Home Depot, which seemed so long ago, but they really weren't. And also he was the DOJ at the DOJ National Security Division, focusing on nation-state threats. And so really one of the most important, I always look at that job, the head of the National Security Division, is probably second to the Attorney General in terms of the most important law enforcement job on the planet. So that makes Luke the Steph Curry of incident response. He's multi-talented and a true leader. Okay, what you already probably know about Heather Egan. She's a partner at Morgan Lewis, 25 years of cyber. She was part of the very first incident response forum, specializing in the multinational businesses, privacy, the alphabet soup of privacy regulations. Paul mentioned this on the last panel. You don't find too many IR lawyers who really think of themselves as privacy experts as well. I think that's just because it's so hard to keep up. But Heather is an expert on that alphabet soup. What you may not know is she was guest lecturing in my class. It's just how tough Heather is. She was guest lecturing in my class I teach at Duke on cyber. She was, via Zoom, she was pretending to be a board member, and the students were briefing her about an incident response. And in the minute, we suddenly lost the image of her in the middle of the class, and I'm trying to figure it out. And then it comes back on, and there she is sitting calmly. And I said, what happened? And she was out in a park, and she had gotten mugged. Someone had tried to steal her laptop. She fought them off, kept her laptop, and continued on without, as if nothing ever happened. And she's like, yeah, it's going over here. You can see it. She turns her laptop, and there's the police handcuffing the person. And she's like, no big deal, John. I'll keep going. So she's got to be the Sarah Connor of incident response, the young and the older version. Okay, next up, Pat McNally at Octillo, very interesting firm that really specializes only in cyber. That's another thing that we've seen. We know that's true with the Mullen Coughlin firm and also the Beckich firm. All these firms just do cyber. It's kind of interesting because 10 years ago, a lot of the big law firms didn't even do cyber, and now you have law firms that do exclusively cyber, leading through all stages of IR, notifications, strategic communications, everything. What you may not know is that he was technology and data manager for voter protection in the Biden 2020 campaign, and a long history relating to voter protection and integrity. And he's taken on all sorts of adversaries in that role. And that makes him, of course, the Jon Snow of incident response, a true protector of the realm. Okay, next up, last we have Michael Sussmann, a partner at Fenwick and West, former CSIPs and DOJ. I met him when I was chief of the Office of Internet Enforcement. He was at DOJ, and he was working on the manual for prosecuting computer crimes, searching and seizing computers, and obtaining electronic evidence in criminal investigations and prosecuting IP crimes, while he was with CSIPs as well. So that goes back again, maybe 2000, maybe 25 years ago. He was working on this stuff, which is really, really terrific. Without getting into the details, I think suffices to say that Michael Sussmann, that's two N's on Sussmann, that's my typo, wins the prize for being the absolute toughest lawyer in the conference. Everyone understands why. And that makes him the Daryl Dixon of incident response. And if my friend Michael Sussmann had a theme song, it would be I'm Still Standing, Elton John. So thanks to this panel, and really honored to be standing here with you guys today. So carry on.
Thank you, John. I think I learned more from your introductions, sometimes about myself, than I might from the panels, but they're really incredible, and thank you for that. And this truly is an amazing group that has joined us here. Unfortunately, our FBI speaker got pulled away, so we will do our best to represent, our experiences with the DOJ and FBI and other government speakers. But Heath was not able to join us here ultimately. So, Heather, I want to start off with you. We heard for years, in fact, you and I were talking in prep for this, that I think it was the first one of these I attended, first IR forum, about 9 years ago, when a speaker familiar to both of us told the audience, never call the government about a cyber incident. Nothing good will come from that.
Yeah.
And I was fresh out of the government, and I was a little bit stunned, even back at that time, that view would be, spoken from the stage to the audience. But much has changed over that decade, and I'm wondering if you can sort of explain what you've seen as the evolution in cooperating with law enforcement in general on cyber cases.
And in fairness, the gentleman who said that, for those of you who were here at the time, he was referring more to and it's not law enforcement, FBI, traditional, what you might think of law enforcement. He was thinking more along the lines of the regulators, that no good deeds, that cyber, in many cases, the companies were not treated as victims. They were treated as the perpetrators. And often you make a report, even voluntarily or proactively, and that would then be used against you. And, and I think historically it was. So I've seen shifts even at the regulatory, so the government agency standpoint today, which we can certainly talk about. There have been some shifts, even with the notoriously most difficult agencies to interact with. Some of them, not all, but so I've even seen a shift of that in the last 10 years. But in respect of working with the FBI in particular and Secret Service in a post-breach context, or even in the middle of the breach, what I've seen, especially under Christopher Wray's leadership, was a real intention to develop partnerships with the private sector. Intentional, concerted, meetings in advance, really trying to build relationships. The expression that he would use was, let's thatch the roof while the sun is shining. And that's, as for any homeowner, that makes a ton of sense. Mm-hmm. And it made sense in our practice as well. But the direct effect that I saw, and where I really saw it come into play, was when Scattered Spider was in its most active state, affecting companies so dramatically here in the United States and elsewhere. But I think before Scattered Spider, there was much less proactive engagement. It was through the Scattered Spider experience, which I think was so salacious and got a lot of press attention, that the District of New Jersey office, which was handling those cases, I think at the beginning botched it, because whoever was trying to handle those cases was not doing a good job coordinating. We went to them to seek proactive help and weren't getting the proactive help. They course corrected that quickly. And my experience in the post-Scattered Spider and through those relationships is that even today, with Brian Vondran being elevated and his approach being very cooperative and pragmatic, my experience now is that we are getting a level of cooperation, and they do in fact treat the companies as victims instead of perpetrators. Now, that said, I think there are some real themes that we need to tease out here today about what are the limitations when you're dealing with a portion of the Bureau that wants to be cooperative. There are still potential limitations. We've got issues of information sharing. We've got the fact that disclosing information to the Bureau is not going to be privileged or protected, and in fact can and will be used against a court of law by some of the other agencies. And so we can talk more about that for sure. But my experience today, and I used to say, because clients will think, oh, should we call the FBI? And there's this misperception that law enforcement is going to come charging in and like arrest someone instantly in the moment. And so there's a little bit of a dispelling those myths when you're giving legal advice in the incident response context. And so typically what I explain is, look, there are a defined set of cases in which we want to proactively engage with FBI. And one that I'll raise for this group today that I think bears discussing and is important to think about is the increasing use by the threat actors of virtual private servers. And so if a threat actor comes to you, let's say on Monday, you experience the breach, the threat actor increasingly is likely committing that attack using virtual private servers. Virtual private servers can be wiped away very quickly. So you've got your IP addresses, right? Maybe by Tuesday, you're able to get a list of IP addresses. If you even wait until Friday to go to law enforcement to give those IOCs over, by Friday, they're likely stale. Those servers are wiped away. And so I think as incident response counsel, one of the things we need to think carefully about today is how quickly, and that's where I think things are changing, is it's the technology environment where it may be that you would wait 30 days even to engage proactively with FBI and turn over your IOCs, that you may want to think about doing it sooner in certain cases where either the client you know is going to have an interest in participating or cooperating in the potential prosecution of the perpetrators, and not every case that's the case. And if so, to move quickly to try to get the indicators of compromise into the hands of law enforcement, because only then are they likely going to be able to gather the types of evidence that they would need in order for attribution, for the investigation, and potential prosecution. So I'll pause there because I know I threw in a lot.
Yeah, and that's great. And we should come back to some of the points at the end, but like you dispelled a couple of the big historical myths. One is we lose control, like they're going to come in with raid jackets, like the old, views of these things. Occasionally we still get a question or two like that from a client, but another one that was more common or more prevalent, I think, in the last years is we're not going to hear anything back. We just provide something and we never hear anything back. And under Brian, and even to some extent predating Brian and so forth, and Chris Ray's tenure, we got a lot of useful information back, as is implied by your point about IOCs. We'll come back to that. Pat, I want to turn to you and bring it forward to right now. What even for sophisticated clients, it's not always a given that we're going to make the initial report. And we're distinguishing right now, just to be clear, the initial call from a later decision, which I want to talk about later on in our panel, about, okay, we're going to prosecute, we've got a human we're going to lay hands on, will you support the prosecution? I'm talking about the initial report phase and the decision. There's still some concerns now, right? And are you seeing the same thing, and what are those?
I think naturally there's still a good number of concerns that come anytime you're having a conversation with law enforcement, because any information that we ultimately are providing to law enforcement could potentially be shared with other agencies in the United States government. Now, I think I agree entirely that the FBI has become a victim-centered organization as it relates to cybercrime. And I, just from working with Brian, with his team, with Cyber Division and agents across the country, I have a high degree of confidence that when they say, no, it is our policy not to share this information further with regulators, with the SEC, with the FTC, I feel a good degree of confidence in that. But there's always the uncertainty. There's also always considerations around attorney-client privilege and how you can provide useful information to law enforcement in factual form, but that will still protect the analysis and the legal determinations that you're making along the way. Back in the day, the first request was just, can I have your forensic report? Well, no, of course you can't have any forensic report. In fact, we may not even have produced a forensic report, but you can certainly have these IOCs, which will assist your investigation. I think so much of it comes back to, what is your objective for making that initial report? Is it to gain visibility in threat intelligence, given the FBI's wide experience with different threat actors across the country? Is it because you want that for narrative purposes, to be able to say later on when we're reporting or notifying individuals that, yes, we went to law enforcement right away? Is it because you may need to make a ransomware payment and there's OFAC sanctions considerations that we'd like to mitigate? Or is it because we really do want to help and assist the FBI's investigation? I know many of our ransomware victims want to bring consequences to the bad guys that did this and want to assist the FBI in a really genuine way. So I think so much of it is just considering the potential risks out there, really thinking through what's your strategy for why we're making that outreach to the FBI, thinking about how we do it, which I know we'll get into on the panel here, and then weighing those different considerations with our clients so that they can make an informed decision about what makes the most sense, both from a benefit of learning from the FBI as well as providing them information.
Yeah, great points for sure. Michael, does it matter what kind of case it is? I mean, if it's a national security case versus a criminal case, where do the case-specific factors notwithstanding, where does it lean in different types of cases in your mind? Or maybe it doesn't lean at all, it's the same.
Yeah, I mean, I think it breaks two ways. There are instances where you know which it is, and that might affect your decision about what you want to do with it. But there's also many instances when you don't know if you're dealing with a nation state or dealing with a criminal actor, and learning that from getting that feedback from FBI, which you often will get, can help you in what you're doing. And so a couple of big differences are, if you know that it's a foreign state actor, likely not ransomware, more likely your data is not going to be leaked. It's not a criminal act, and so there's generally better news in that regard, regarding publicity. You still may provide notice, but you're not dealing with a criminal actor. On the flip side, those actors are harder to eradicate and get rid of, and sort of get rid of the persistent threat. So it's a bigger challenge having them around.
Yeah, we've certainly seen a greater inclination to reach out. I mean, our practice is a lot of former prosecutors, computer hacking and IP or chip prosecutors and the national security equivalent. And we're sort of wired to report in general, but it's not automatic. It's not automatic. But in national security cases, there seems to be more of an inclination to wrap oneself in the flag a bit and lean on the government. As a practical matter, and maybe one of you could comment on this, it sometimes can help bolster like a risk of harm analysis. Like in criminal cases that are persistent and national security cases, they can generally touch a lot of the network. If they've got the Active Directory, they could have looked at this or that. And if that were the standard for who you notified, would be basically notifying everyone in a lot of cases. And we've tried to bolster what we learned from the Bureau and the DOJ and others about the threat group's proclivities to kind of inform our decision that way. Mm-hmm. Have you found that useful?
Yeah, absolutely, because more and more, the instances where you have a threat actor and you know exactly what they've done in the network are, there are lots of clients that don't have great logging, and you come in there and you're having to make assumptions and try and make the best recommendation you can as to what you think happened with regard to unauthorized access. And so you're looking to get information internally from your logs, externally, and the Bureau or others from law enforcement can help you confirm what you may think. We know this actor, this is what this actor does, or we had one recently where it was a scam. And they said, yep, this is actually not a real ransomware thing, it's something else. And so sometimes the outreach is just to get more information because you're having to advise a client about providing notice or not really sure what the threat actor may or may not have accessed. And so you can get more information that way.
Yeah, we had a recent one where it was nation state. It was a particular flavor of threat group within that nation state's repertoire. And understanding that it was this group that's very politically minded and they have a particular mandate. It was a Chinese group. It was one of the typhoons, but a particular one that's even more shadowy than some in the news. And they looked at only a few people's emails out of the whole kit and caboodle that they could have looked at. They went after just select items. And that can be hard to explain. Well, if they had access to everybody, and there's the CFO's mailbox, that wasn't even bothered. No one looked there. Are you sure your logs are right? No, this aligns with what this threat group, is known to do. Heather, I think in our prep, you're the one who mentioned the kill chain.
Yeah.
Financial product kill chain. Could you explain what that is? Because not everyone may be familiar and why that might be an example of a fast call.
Yeah, so we're increasingly seeing vendor payment diversion through spoofed email attacks or actual compromise of email. And so if there is a payment that's made and you sort of detect that you've made a payment in error or pursuant to one of these scams, and or it's reported to you that maybe your vendor or your customer has made the payment, within a 4-day time period, you can, through notifying the financial institution, you can notify one of the law enforcement agencies, and they'll kick off what we call the cyber kill chain, the process of trying to stop, through the electronic transfer of funds, the movement of that money or the withdrawal of that money. And if you could do it within the first 4 days, get that notice in, a very quick notification, we've seen good success at being able to claw back those payments. After the 4 days, it's really, it just totally depends on the circumstances, but I would still say it's worth starting with the bank, making a report to the bank post 4 days. So that's an area where you might want to be more proactive in getting out there with a notice.
Yeah, and the vehicle to kick this off, so it's the FBI's CyWatch program, is through IC3, the Internet Crime Complaint Center. And I have a different question for you in a second on that, Pat. But you'll see there's a tab there for BEC, or Business Email Compromise, which other panels have mentioned, and it's kind of a way of suggesting wire diversion. And if you will make that, fill out that information, there's a 24/7 jump team for CyWatch, and there's a network they've worked out with FinCEN and their foreign counterparts in many jurisdictions. So we've successfully interdicted wires in Mexico, in Japan, various places. They won't try it after 72 hours, so they won't even pull the lever and invoke it. But if you fill out that wire information, we've gotten calls from a party we've not had as a client, and they're like, well, we should do an engagement letter. I'm like, no, the first thing you should do is go here and fill this out, worry about the engagement letters later, get this interdicted, and then exactly as Heather said, you go to your bank, usually in the 3 or 4 days, go as fast as you can, double track that with your IC3 filing. But Pat, sometimes we got pushes from the bureau when we would call to say, well, go have your client do an IC3. Why are you calling us, the field office? It's especially true if it's not a frequent flyer office, like maybe we haven't reported there before. What are the pros and cons, and when do you advise your client to either, in lieu of a direct field office report, make an IC3, or maybe in addition to?
Absolutely. So I think already, Heather, you and Luke have identified the best use of the IC3 is exactly for misdirected wire transfers to get to the recovery asset team and get that process moving. Outside of that, I greatly prefer, and so much of it just depends upon personal relationships and being able to reach out to cyber division and to field offices across the country. I will always prefer to pick up the phone and talk to an FBI agent. Best case scenario would be if it's someone that we've worked with previously, if it's someone who is in the specific field office and the team that's investigating the specific variant of ransomware or other malware, because at that point, once you've already reached the case agent, you're going to receive the best information, and I think you can also provide the most useful information to them. Where an IC3 report can also be useful to clients is in the documentation stage, even afterwards, where we've already potentially made those initial reports, had meaningful conversations with FBI agents along the way, but perhaps we did have to make a ransomware payment, and now we really want to memorialize, those conversations with law enforcement, perhaps for an insurance company, a financial institution. And that is also where we will use the IC3 report as a way of documenting, just saying, on these dates, we had these conversations with these agents, and now we're submitting it into the system. We're always conscious of anything that goes into IC3 is not just going to FBI, it's also going to other government consumers, which can include regulators, because while the FBI has very, I would say, strict policies about what information is shared with the regulatory agencies in USG, not all of their partners on the law enforcement side have those same bright lines, and so that is certainly a risk of any time you're submitting an IC3 report, something to consider before you do so.
Yeah, and we've had clients use it as well to report things that really weren't a cyber attack on them, but an impersonation, like a false site or social media site recruiting investments, recruiting employment. They want to make a report, but they could literally be on the phone with the FBI every day if they viewed all those as their problem, so to speak. But an IC3 can be a way to do that. One, sort of practice tip that I adhere to is if you've got victims of said investment or employment scam, they're usually all over the world. We don't reflexively just provide those to the FBI portal, given the sensitivities. We try to say, we're aware of 17 victims. If you'd like to provide info, if you want to follow up with any of them, let us know, and we can play Cupid and let them decide what information they're going to share with you. That just also reminds me of a point that we hadn't touched on. We're assuming so far U.S. law enforcement. It can be very different, for foreign law enforcement. For example, if you make a report in Germany to the BKA, the rule is that they must open an investigation. It is not discretionary to the victim whether you're going to support that. If you call the BKA and you provide the information in the client's name, you have pulled a lever. And they are excellent, they're very good at it, but they don't have a choice. And so it's always a different consideration, or maybe we approach it as a hypothetical to start and find out, could they help us? How would it go? Give us a roadmap to what it would do. Things are evolving. For example, in the UK, they've got their own portal action fraud. And I think they're actually trying to soften that approach, is our impression, to have it be a little more user-friendly like you can do with the FBI. Did any of you want to add anything on your foreign law enforcement coordination?
I'll add 2 points. We start by talking about sort of U.S. law enforcement reporting and what it's like to report to FBI versus Secret Service, and state, local, and there could be big differences. That explodes internationally. And so the question about reporting, and Pat, you talked before about like the different reasons why you'd want to do it, it depends on the country. And it's a big world, and so there are a host of countries where I know who to report, I know what happens, but things come up all the time, and I don't know what's going on with law enforcement could be the Philippines or could be somewhere else, and so you do your own detective work, talk to someone who you know, or maybe reach out to the Bureau and say, I've got something in this country, like which is the agency and what really happens from it. And so it requires a lot of digging, and then in setting expectations for clients, it's one thing, and it's challenging enough now to talk to clients about what outreach is going to be is like with the new administration, but it's hard to give sort of guarantees and predictions internationally. So it's complicated, and then there are times when it's not just one jurisdiction. You're sort of making a decision about do you go internationally or not. And internationally isn't just one country; it's a number of them, and it can be hard to report to some countries and not others. And so it's complicated, and the more information you have, the better, but it really depends on where you're going.
So back to the...
Oh, sorry, one last thing.
Yep.
The other big dividing line internationally is, do you want to reach out directly to foreign law enforcement, or do you want to go through the FBI legat?
Yeah, great option to do that, and they can usually steer you right. Well, speaking of the U.S. and making a report there, Michael, what are your practice tips for people making a report to the FBI, Secret Service, other U.S. agencies?
Yeah, the one which we've touched on, the most important one is finding the right place to go.
Yeah.
And it's not that hard to do, right? Like the wrong agent or the wrong office doesn't want to take it from you. And so sometimes you know, and sometimes you ask. We recently were dealing with a threat actor from North Korea, and so made a call or two, but we found in the Bureau the unit working on this and the woman who was in a particular office who was doing this case, and that was perfect, and that's what you want to do. And so sometimes you know the person, sometimes you'll reach out to the big office in the area and then just ask, like, hey, we've got this thing, is someone working on this, where's it going to go? But that's the most important thing, is finding the best place to do it. It can get a response or get a response more quickly. So that's probably the most important thing. And then trying to get confirmation or attribution is really one of the most important or helpful things to do. And there's just so much more. You were asking Heather before about the evolution. There's so much reciprocal sharing now, and so just getting all of that help that you can, and and then keep making a record of what you're sharing, because I think you may get this a little bit later, but share now, and then here 2 years later when a case is coming to trial, that you're now, your client is now an important part of the case. So having a record, it's always good to have a second person on the call or in the meeting with you when you're making that, so you've got a clear record of what you're sharing. Tie it up.
Can I pull on that reciprocal sharing thread for a minute too? Because I do think that one of the big values of thatching the roof and establishing those relationships is the ability to be in the room with your client and get briefings on how the case is progressing. That the law enforcement will notoriously say, look, we can't go into too many specifics, we can't share, but it is pretty remarkable, and I think gives the client a lot of comfort to hear that the Bureau is conducting the investigation, here's where they are in the stage, this is what you can expect to happen next. There's often this back and forth, you can ask questions. That allows the client to go back and report up the chain, especially when it's been a significant cyber incident that has material or even not even materially impacted the organization, to be able to stay on top and stay in communication. And so I think sooner rather than later, also working with the DOJ, with figuring out who is the assistant U.S. attorney who's been assigned to this case, and establishing a line of communication with them as well early. Because at some point, if you do in fact get to the point of a charging document or something that's going to be filed in court, many of our clients don't actually want to be named in that process, right? And so they don't actually want to be, if they're victim number one, victim number two, whatever it is, that there's, I think, a negotiation to happen about how descriptive, even in describing the organization. Because, if you've got one financial institution that's headquartered in this region that happens to specialize in this particular type of the financial sector, everybody then knows who they're talking about, even if it's supposed to be anonymous. And so figuring out early on, establishing that relationship through a reciprocal dialogue back and forth, and cooperating in that process early, I think makes a ton of sense for clients.
Yeah, great points. Pat, anything to add in terms of tips? I mean, do you make it a verbal report and then just document it on your own? Understanding, for those of us that were prosecuting these cases, we may have had to produce what you write. So just emailing a bunch of details can have to be produced or shown to the defense.
No, certainly, and I think, Michael, you made a great point about documenting that internally, so that we can have that second attorney or paralegal, another colleague in the room, to really try to get as verbatim as possible notes as possible from that, so that we at least have that internal record. I think that big question does come up so often of what to do 2 years later when the government actually wants to use that information for a prosecution, when your client may have different leadership, when your client may never want to think about the cyber event again. And that can be a really difficult client management situation. One thing that I think is important for us attorneys to always try to do is to follow through on the promises we make to law enforcement, in the sense that so often, I think we've all had cases where I know I have said, oh, absolutely, we're going to get you IOCs, we're going to get you IP addresses, we are going to fly to Belarus ourselves and bring this guy back. And then I move on to the next case and the next case and the next case, and I don't always follow through on that. But I think that one thing we can do, while we can't control our clients' follow through, we can be careful about what we as attorneys promise on the front end, to say, I'm going to do my best for this, we're going to really work hard on that. I can't guarantee you that the client's going to want to go all the way to prosecution, but we'll do what we can, because that, I think, will only strengthen the relationship on both ends for future cases when we're asking them for favors, as we so often do.
Yeah, great point. At least thus far, the government hasn't, the U.S. government hasn't taken the approach that we're going to force you to be a victim named in the case, or you gave us this evidence up front, therefore it's part of our charging documentation, and we may need, you know, an affidavit or whatever from grand jury or testimony. You mentioned, Heather, like company 1 or company A. So for example, in the North Korean type cases that Michael talked about, the government has been bringing those cases predominantly against the domestic facilitators, you know, the laptop farm people that are hosting and powering up devices and so forth, where they're going in and doing like the I-9 paperwork and other so forth. So they're today's money mules, if you will. And in those cases, they've been calling it company A, company B. No one has gone to trial, and you can probably get away with that even if they plead and you're in the you know, you're in the sentencing phase. But it's a little tricky at trial not to have something with the victim's name or the media dig in and figure it out. Is that something you you warn clients about?
You warn them about, but things change. I mean, you can warn them, but again, 2 years later, they're different people, and there are times when the client can back out, and there are times when the government doesn't want them to. There's a public case, I represented a big company that had 2 insiders from Saudi intelligence. One fled, and then one was tried, and the government wanted that case, and at that point, you know, they had the witnesses from the company, and it was a frenemy-ish type thing navigating that, and that's par for the course.
Yeah. What about where you draw the line in terms of what you don't share? I mean, I think it was said early on, we don't give the forensic report over, I think it was the last panel, that, you know, we may not even be writing one these days with all the litigation going on. Where do you draw the line? I mean, do you give them, we talk about IOCs or indicators of compromise, TTPs, techniques, tactics, and procedures, like they live off the land, they move this way through the network, this is their average dwell time. But what about like raw logs and so forth? Any type of system image?
Well, I have a different kind of line. So IOCs and bad guy stuff is great to share, but oftentimes our client is screwed up, right? Like there's no MFA, like there's some problem that were a root cause, and that's difficult. I mean, I'll try and keep that on the privilege side, but that can be a really, and it's not necessarily a bright line, but I don't necessarily want to share how that happened if it's a negligence story.
But I think all of this information has to go into our thinking about how are we reporting this, what degree of cooperation. So if we know that when we make a report to IC3, it is going to be shared with other agencies and who's that control, versus your preference, which is like mine, which is to pick up the phone and either call the local field office or call the field office that we know that's handling the threat group. And in that case, so are you early on in the investigation? Are you further down the road in the investigation? But sort of knowing what okay, and if based on the investigation, you know that it was one of those problems, I'm less inclined to file an IC3, lose control of the investigation potentially, more likely to reach out, especially if I think I'm going to make a ransom payment and I need to meet my OFAC requirements, and the fact that the cyber carrier is going to require that I have reached out to FBI before authorizing that they will reimburse the payment. So there's a whole host of sort of the order that you have to put it in. But my experience generally with, and I know I'm saying then that I'd rather pick up the phone and talk to an agent live. Rarer is it that I'm going straight to IC3 unless I just need to tick the box. All of that said, there are examples and random examples for any of you who I'm sure has been since you're in the cyber business, you've been at a cocktail party and someone told you about this horror story that they had happened to them personally, where they've, either fallen victim to that Apple gift card scare. I will say that I had my hairdresser, my poor lovely hairdresser one time, fall victim to the Apple, the card scam. She diligently saved all her cards with all the numbers. And so while I was getting my hair done, sitting there, we went up to the IC3 database. We entered every single one of those card numbers in. We did a detailed report about what had happened to her. And do you know that she got her money back I couldn't believe it, but I thought this is a case where successful use of IC3 to actually follow through. And that was a pretty cool case. She was very happy in the end. For her, it was a ton of money. And so you may be the hero at your next cocktail party. Pull out your laptop and use IC3 to your advantage.
Yeah, I'm sticking with you with the laptop wrestling story. And, hairdresser wins the day. So Pat, I'm going to start the unfair questioning with you about, do we think it's going to change with this administration? Do we think cyber will be, less of a priority or thought of differently? Will anything change, that you could predict?
I think it is going to change, but I don't think we yet can say how. I think there's an element of unpredictability here, sort of across developments throughout USG, that I don't think that I can say, I think it'll go in this direction or a different direction. What I can say is that I have a lot of faith in those who remain, both in cyber division and in field offices across the country. And I anticipate that probably many of us will require to continue to really reach out to the field offices for the men and women who are on the front lines, the special agents, the analysts, the folks who are really, the boots on the ground with the investigations. Like those, I'm really confident they're not going to change as long as they can just do their job. So I am looking forward to continuing to work with them, and I certainly hope that Brian and the great people at Cyber Division continue on in the same direction. But hard to say for sure.
Michael?
It's unknown. Everyone's afraid, and I tell clients, like, I don't know. I'm looking forward to the panel in 4 years when you say, like, where did it all happen? But if you're at a law firm and you're under an executive order now, is the FBI going to respond to you? And look, I agree. The agents that are working the cases want nothing more than to do the work that they've been doing. Yep. But it's really unknown. I had my current partner now was Chris Ray's chief of staff for 3 years. We had a cyber thing recently, and in the course of we called someone, and that person was gone. And within a week, we called someone else, and that person was gone. And so it's really unknowable now. I think that we will all try and do what we've been doing to work on the cases that we've been working, but
that has to be part of the conversation with the client early on, which is, how is this going to impact? Knowing things could change, that is a huge, and I think my experience now has been, just even in this short period of time, that it is having a chilling effect on a willingness to want to be proactive and cooperative when it comes to information sharing, and that's unfortunate. So we'll see how it plays out 4 years from now.
Yeah, I mean, as one of the last panels talked about, some of the variables on the threat actor side, how there's less predictability. Jennifer and some others made, I think, spot on comments about how those variables have changed, can't predict it as much. One variable, frankly, that I think we haven't had to worry about in recent years is that we could trust that, this agent telling us they're not going to share this on, or that we won't come to you and force you to be, in an indictment or charging paper, that we could rely on their word, because they have done the spade work with all of us over the years to come out of their shell and come to events and interact with us and set up vehicles to build trust. And I think, as you each said, it's TBD. Will we see any particular change? We might see in practice just a little bit fewer resources at the area, thrown at the area. We might see some things pushed more to just the field office level. I think it will be increasingly important, if they keep it to what you implied early, Heather, is that, for example, Newark was the lead on Scattered Spider. They had Lockbit. Knowing which office, to Michael's point, to go to, like who in our big government, if there won't be as much communication with air traffic control and headquarters, it's going to be up to us to build the networks and know who in a particular field office is the lead on this group or that group, so we're getting straight answers for clients. So, well, I want to thank each of you for doing this and doing double duty without Heath able to join us. So thank you, and Bruce, we'll turn it back to you in time for lunch.